Today we're going to talk about custody of minor children under Oregon law. First, the law of custody is basically the same whether you're married or unmarried. Custody has two categories. There is physical custody, and then there is legal custody. Physical custody is basically who you live with, who the child lives with. Legal custody is a determination by the court that awards custodial rights to somebody. Legal custody can either be joint custody or sole custody. Joint custody basically is shared decision-making concerning the child. It does not mean equal time per se. In fact, you can have a joint custody order where a primary physical custodian for the child is designated, but you still get to collaboratively approach decision-making. Sole custody, on the other hand, is what happens when you don't agree to joint custody, or when a parent objects to having joint custody. The court cannot award joint custody in Oregon when a parent objects. In that case, the court has to make a sole custody award to somebody. Now, in practice, there's not a lot of day-to-day difference between having joint custody and sole custody, because in either scenario, the days and the times that the parent spends with the child will be set forth in a parenting plan. And a parenting plan is equivalent to what we used to call a visitation order. We don't use the term visitation in Oregon anymore. Here are the rights that a parent gets when you have sole legal custody. And as you can see, this comes down to what I call the big three, and that is the right to be the final chooser and decider for issues concerning school, healthcare providers, and in a qualified sense, the religion. What is not on the big three is the right to move with your child to a place far away. In some states, you can do that with a sole custodial award, but not in Oregon. You have to get court permission if the other parent objects. Now, here are the rights of the non-custodial parent. And as you can see here, these are statutory rights. They are actually embedded in our statutes. And I think the bottom line to remember here is that if you have sole custody, you can choose the big three, particularly schools and medical providers. But if you are non-custodial, you still have all the same rights as the custodial parent does in order to access information and records concerning your child to the same extent as the custodial parent. And that's one of the reasons why there's not a lot of functional difference on a day-to-day level between being a custodial parent and a non-custodial parent in this state. So how does a court decide custody? Well, first, it's generally better to agree to custody and a parenting plan. You know your kids better than the judge does, and you know their individual needs and preferences, and you know what's going to work in your life realistically, especially if you have different work schedules. And so always try to mediate before you bring your matter to court. If you do end up in court, here are the factors that the court will look at when determining the best interests of the child, and that's the task of the court, the best interests. There are 6 basic factors, but I'll isolate one in particular, and that is the preference for the primary caregiver. And that is not just the logging of more hours than the other parent, but it is also the quality of that time spent. You know, the primary caregiver is the one who generally takes the child to the doctor, generally meets with the school and deals with school activities, generally would be the person who is the go-to person if the child is sick and somebody needs to stay home from work. Those are just some examples of what makes for the primary caregiver determination. And the reasoning behind this is, let's not change what's already working. However, if there is no practical distinction between the parents in this area, then we have to get into all these other factors and see which factors are most predominant with one parent versus the other. Now, there are also non-factors, I call them, for custody, and these are also found in statutes. And the non-factors are things that the court actually does not consider ordinarily in making a custody determination. And I'm going to add one to that list of statutory factors. There is another non-factor generally is the wishes of the child. There is a myth in Oregon that I've seen where at a certain age the minor child gets to choose their parent or choose who they get to live with, and that is not the case in Oregon. An older teenager's preference may be taken into consideration by a judge, but the court is the final decider, and this is frankly an effort to keep children out of the middle of proceedings. The court considers custody in a trial without a jury, and trials are public and anybody can go to them. It is always best to get legal advice if you are involved in a custody dispute. The earlier you get your legal advice, the better. You have more options available to you earlier in the case. If you have any questions about a custody matter, please feel free to give me a call and set up an appointment so that we can discuss it further.